2 years ago, 3 of my colleagues dissented from the Prane decision. They said the majority's absurd holding allows Prane's 6-year term on the Board of Natural Resources, which expired over a year ago, to last for as long as Prane wants it to, so long as he refuses to leave and the Senate doesn't confirm a nominated successor. Why haven't you asked us to adopt the dissent in that case? Because that would get you the outcome you're seeking, right? I go back to the dissent again. It said the majority bases these nonsensical conclusions on its misguided reading of a handful of statutes and a common law doctrine, de facto, de jure appointments.
Well, Your Honor, we certainly agree with the majority decision in Prane, but what is happening here is far more absurd. There you had a traditional constitutional standoff between the governor and the Senate. They didn't agree with the appointment. That's resolved in a holdover. Here we have 3 essentially bureaucrats who have no constitutional status holding the chief election officer appointment hostage away from the people. This is night and day from Prane. And these folks are saying that they're not going to send it over unless the constitutional body pre-commits to confirming their pick. Or we're not playing your game, and the game being advice and consent.
Let's talk about the game. I mean, you are trying to thread a needle here that has no eye. 6 of the 7 of us sat in this courtroom 2 years ago when your client insisted that Fred Prane should be able to retain his position on the DNR board even though his 6-year term had expired, and your client won. This is a case of careful what you wish for, isn't it? And now the legislature is here 2 years later demanding that Meagan Wolfe must vacate her position. It seems to me this has little to do with what the law actually says and far more to do with who is in these positions.